The case of Lergesner and Carroll is an amusing case from the Court of Criminal Appeal in Queensland, Australia. The case tested the definition and limits of bodily harm in the Queensland Criminal Code. Mr. John Glenn Carroll and Mr. Peter Lergesner were police officers in Queensland. The two men worked the same shift together, and during that time the two men had what was described in the court as a heated discussion about mangoes. When their shift ended, the two men both went to the police social club area with the appellant Mr. Carroll following Mr. Lergesner to the bar. Mr. Carroll took a position at the bar near Mr. Lergesner. There was a nearby tin of money belonging to the club, and Mr. Lergesner said, "I'd better put this tin away, you can't trust too many people around here." Mr. Carroll had previously been investigated for a stealing offence at Mount Malloy, of which he was acquitted. He believed the comment made by Mr. Lergesner was to antagonise him. Mr. Carroll said to Mr. Lergesner, "What do you want from me? Do you want to settle this on the grass outside?" Mr. Lergesner responded, "No, let's settle it right here and now." There was a pause as the two men stared at each other briefly. Mr. Lergesner asked Mr. Carroll, "Well?" and Mr. Carroll responded by punching Mr. Lergesner in the face. Mr. Lergesner reacted to this by punching Mr. Carroll in the face, causing him to fall against a nearby refrigerator. Mr. Carroll then attempted to kick Mr. Lergesner in the groin, who deflected the blow with a kick of his own. Mr. Carroll punched Mr. Lergesner a few more times about the head and body before Mr. Lergesner gave up the fight. The judge held that the magistrate at first instance failed to properly consider Section 24 of the Queensland Criminal Code, dealing with honest and reasonable mistake. The appeal was therefore allowed and the conviction was quashed, meaning a new trial was to be held. The court provided two pieces of insight into law in this case: the limits of consent and the extent of what can be considered bodily harm. With regard to consent, the court held that while one can consent to an assault, they cannot consent to harm at or above the level of actual bodily harm. With regard to bodily harm itself, the court held that a black eye or bloodied nose could be considered bodily harm as it interfered with a person's health and comfort as defined in Section 1 of the Queensland Criminal Code. We got this insight from the court because two men had a fight caused by a disagreement about mangoes.